Hello guys and welcome to LawPutra's YouTube channel. Today we will discuss about the different types of specific relief that can be granted under the Specific Relief Act 1963. I am Jagannath Kulkarni. I welcome you all to this discussion. The Specific Relief Act 1963, let us see why it was enacted. So many times damages or compensation given to plaintiff are not enough. Hence, this Act, Specific Relief Act, talks about the reliefs which are enforced by court on other party which fails to perform its duty under some agreed contract between two parties. Relief is provided by non-performing party itself as monetary compensation in form of damages who could not satisfy other party in contract. So this is as simple as this. Now, specific relief can be granted only for purpose of enforcing individual civil rights. Remember this always. It is for protection of individual civil rights and not for mere purpose of enforcing any penal law. And this is the specific relief to be granted only for enforcing individual civil rights and not for enforcing penal laws has been provided for in section 4 of the Act. Now, let us discuss about what is primary right and secondary right. Now, this Act provides specific relief in deserving cases and it protects and enforces primary rights of suffered parties. In civil law, legal remedies are for enforcing both primary rights or secondary rights. When there is a breach of contract and if court orders specific performance in favor of innocent party, then this will be enforcement of primary right because the performance of the contract is important, is primary. But if the court orders payment of damages for damage caused, then it will be enforcement of secondary right. And this act is meant for primary rights. Remember this. Now, what are the remedies available under the act? The first and foremost is recovery of possession of property. 3 sections, section 5, 6, 7, 8, 4 sections have been provided. Second talks about specific performance of contract, section 9 to 25, so many sections. Then rectification of instruments, section 26, rescission of contract, section 27 to section 30, and then cancellation of instruments from section 31 to section 33, and declaratory relief under section 34 to section 35, and lastly preventive relief, which is commonly known as injunction or stay order, that is section 36 to section 39. Now let us talk about the first remedy, which is recovery of possession of property. Always peaceful possession of property is essential for maintenance of law and order in society. CPC provides relief per se, relief to those who have been unlawfully dispossessed of their property, immovable or movable, whatever. So, section 5 provides for recovery of specific immovable property. It is as per the CPC provision, Code of Civil Procedure provision. Now, section 6 talks about suit by person dispossessed of immovable property. This is very categorically says if any person is dispossessed without his consent of immovable property otherwise than in due course of law, then he may file the suit. And in one case, that is Puthukattil Parangodan versus Parameshwaran AIR 2002, it has been mentioned that this section seeks to prevent violation of law and order by restricting a person using force to dispossess another person of his property without the due course of law. So this is the case for section 6. Now, section 7 talks about recovery of specific movable property. Again, it says it can be done through by CPC procedure, Code of Civil Procedure, but for possession of movable property to beneficial interest in which person for whom he is trustee is entitled special or temporary right to present possession of movable property is sufficient to support a suit under this section, section 7. Section 8 talks about liability of person in possession, not as owner, to deliver to persons entitled to immediate possession. So this is for section 8. And section 8 deals with liability of person in possession of specific movable property. And in this case, Ganga Vishan versus Jainarayan, the court said relief under section 8 is claimed when monetary compensation cannot afford necessary relief to plaintiff for loss of property, or when it is very difficult to ascertain the value of property. So this is important for section 8. The property needs to be moved. Now, second talks about the specific performance of contracts, section 9 to section 25. Now, today's contemporary modern world, which thrives on intricacy and nuances of contracts due to their utmost significance in economic hemisphere, contracts can be rightly characterized as modern wealth. Remember this, contracts are not just mere contracts, they are considered as wealth, and so enforcement, their performance is very much important. Now, Indian Contract Act, it provides for some relief to aggrieved parties for enforcement of contracts in form of damages. Remember, monetary compensation. But section 10 of this act defines specific performance of contracts would be enforced. There is no standard for gauging the damage caused due to non-performance, and so performance is essential. That is about section 10. These are the sections. Section 9 talks about defense respecting suits for relief based on contract. 10 talks about specific performance in respect of contracts. 11 talks about cases in which specific performance of contracts connected with trusts enforceable. 12 talks about specific performance of part of contract. 13 talks about rights of purchaser or lessee. Then section 14 talks about contracts not specifically enforceable. This is also important section. 14A talks about power of court to engage experts, ancillary section. Then 15 talks about who may obtain specific performance. 16 talks about personal bars to relief. Then 17 talks about contract to sell or let property by one who has no title, not specifically enforceable. 18 talks about non-enforcement except with variation. So it is the qualified enforcement. 19 talks about relief against parties and persons claiming under them by subsequent title. 20 talks about substituted performance of contract. 20A talks about special provisions for contract relating to infrastructure project. 20B talks about special codes. 20C talks about expeditious disposal of suits. 21 talks about power to award compensation. 22 talks about power to grant relief. 23 talks about liquidation of damages, not a bar. 24 talks about bar of suit for compensation for breach after dismissal of suit for specific performance. 25 talks about application of preceding sections to certain and testamentary directions to execute settlements. Now, third remedy is rectification of instruments, section 26. We know that every transaction has to be written. That is the experience of law and prudence. Sometimes instruments fail to express intention of parties involved, maybe due to operative elements of mutual mistake, fraud, then requiring rectification of documents. So section 26 provides for rectification of mistakes. It also says when documents or instruments after their due execution are discovered to be void or thereafter become void, such documents need to be cancelled, and section 31 to 33 provides this relief. So basically, when a document becomes void, voidable, or has a reasonable apprehension of causing serious injury, it needs to be cancelled, rectification. So in this case, Sri Lekha Granites versus Eklavya Singh, the court said an instrument can be cancelled only by a court order under section 31 of Specific Relief Act and not by unilateral means. Section 27-28 lay down detailed grounds for filing a suit for rescission, which may be brought when contract is voidable. Then rescission of contracts is voidable. Contracts are enforceable at option of one party to contract but not other party, and it remains valid as long as aggrieved party wishes to continue with terms of contract. So party at whose instance contract becomes voidable has right to rescind the contract. We are talking about rescission. Section 27-28 provides for the detailed grounds, and when rights over subject matter of contract are acquired by any third party in good faith during course of contract for value implying change of position of parties, then court may refuse to sign the contract. Fifth remedy is about a cancellation of instruments. We already discussed section 31-33. When cancellation may be ordered, 32 talks about what instruments may be partially cancelled, 33 talks about power to require benefit to be restored or compensation to be made when instrument is cancelled or is successfully registered as being void or voidable. Sixth remedy is about the declaratory relief, two sections 34 and 35. At times, person legally entitled to possession or enjoyment of any immovable property might be denied right to enjoyment of such property. In such case, court may issue general declaration as to entitlement of such right to aggrieved party. It also says if a cloud is cast on title of any immovable property of plaintiff, he may dispel it with aid of this discretionary power of court and avoid future litigation. So this is the declaratory relief. Section 34-35 deal with declaratory relief against impugned person who denies or is interested in denying the right to aggrieved party. The last remedy is about the preventive relief, that is injunction, popularly called section 36 to section 44(2) that talks about. It is a court order that either directs party concerned to do a particular act, that is mandatory injunction, or not to do a particular act, order of injunction is issued at instance of court, section 36 to section 40. Objective is to restrain commission or continuance of some wrongful action. It is issued against individuals, public bodies or states, and disobedience of this injunction will be contempt of court. Orders are not granted in cases wherein specific performance of contract or damages is likely to serve purpose of contract, or where damages are appropriate to remedy, or where plaintiff is not entitled to injunction on account of his conduct. This is discretionary relief, may be temporary or perpetual. So temporary injunctions are granted at any stage of suit for a specified period of time governed by provisions of CPC. And perpetual injunction can be made only by deciding merits of suit via decree and deciding rights of parties. In suits for injunction, damages may also be ordered additionally if required. In this case, Ishwarbhai versus Bhanushali Nanda, AIR 2002 Gujarat Court, paragraph 328, the court has said interim injunction can only be sought in cases where perpetual injunction is prayed for and not otherwise. Subsidiary performance of contract is provided in section 20. it specifies for the substituted performance. Notice has to be given in writing, 30 days notice. And suffered party not entitled to recover expenses and costs, and suffered party has got the contract performed through a third party or by his own agency after giving notice, not entitled to claim relief of specific performance. So this is the substitute performance. If you cannot perform, let me perform. And suffered party is not prevented from claiming compensation from party in breach. Specific Relief Act, some contracts are not specifically enforceable. They are given in section 14, that is for subsidiary performance, performance of continuous duty, for personal qualifications of parties, and ultimately contract which is in its nature determinable. Bentham has said this: the law ought to assure me everything which is mine without forcing me to accept equivalents, even though I have no particular objection to them. So this is the crux of the different types of specific relief that can be granted under the Specific Relief Act 1963. Thank you. Thank you very much.